liberty and equality are the promises of our preamble. Coming in that order, justice reigns supreme. Justice comes first. Everything follows. That is the commitment of India. Our civilizational values, our constitutional framework, will all of them give us the fundamentals of constitutional morality. The constitutional morality, as we all, as the students of law know, well, it is going beyond, looking beyond, and at the fundamentals of all the constitutional values, living not by text, but by the texture of what is meant to be. Now, the capability of discerning the texture of anything that is unique to the human beings, that is unique to legal brains, and there the requirement will always be is that we keep our organic intelligence always at the forefront while utilizing artificial intelligence for whatever purpose. It's not a time, sir, to discuss about the fallouts of or the shortcomings of indiscriminate
जो हॉल का नहीं आ रहा है उसमें ग्रुप में एक सीट भेजे थे ना, ठीक है, उसमें हर हॉल का नंबर लिखा है, कॉन्टेक्ट पर्सन जो है, और उसको जिसके पास है हॉल उनको बोलिए कि हम उनको कॉन्टेक्ट करके पूछे कि आप क्यों नहीं आ रहा है, क्योंकि अभी हम एक हॉल में जाएंगे बहुत टाइम लगेगा.
What is needed is for all of us to learn from those kind of examples that the machine is capable of, the machine is tunable, and the algorithms are meant for restoring everything. Whatever goes in, is retained there. It's different than the human mind. The human mind is able to differentiate between right and wrong, correct or incorrect, relevant or irrelevant. So, the fault line with any over-enthusiastic Gen Z person who simply relied on the artificial intelligence output and presented certain so-called citations to his senior. Yes, it was the embarrassment of the senior presenting that in the court, finding that none of them existed at all. But then the machine is, the problem with the machine is the difficulty in unlearning. But we as human beings are capable of unlearning. And that is where we do. So friends, when we are going to discuss this family, we have given praise. I'll be handing it over to them to discuss about certain aspects of constitutional morality and how we integrate them for our purposes. Thank you very much.
Thank you, sir. So we started with a very positive note that probably we are pro-technology, ready to adopt and adapt to this technology and ensure that it becomes a part of the judicial system, provided there is no unintelligent use of artificial intelligence. That's a very correct thing you mentioned, sir. Moving on to Arya. So, although we are ready to adopt this technology, Arya, but there are going to be many practical implementation issues and concerns, especially structural concerns are there with respect to transparency, accountability, preventing algorithmic biases. So my question to you is that what are those key challenges in implementing AI-based tools within the judicial system? And a follow-up question that how can algorithmic bias arise in judicial AI application, and what safeguards are necessary to detect them?
Thank you, Dr. At the outset, thank you for meeting us today. I'm very happy to see everybody having security by Indian standards. Just to straight off that, I think I will be using two terms very frequently. One is JDM, which is Judicial Decision Making, and the other one is ADM, which is Automated Decision Making. So bear with me when I'm running past and using the terms JDM and JDM. First and foremost, in any sort of ADM process, which is automated decision making, How does automated decision making work is that there is a component of artificial intelligence, there's a component of machine learning, there's a component of natural language processing capabilities, commonly known as large language models. So all of these combined over a stack of artificial neural networks collaboratively enable a system where a machine is in a position basis three things to be delivering automated decisions without human intervention. What are these three things? First is intelligent perception. Very basic, what we are currently using in our B2C context is the intelligent perception. You have large volumes of data in natural language which is being processed, and then the machine interacts basis that information with the normal prompt and outputs and inputs. The second phase is called as intelligent cognition, where it gets a little more where there is something called as a feedback loop, where there is something called as a self-learning, which means that even if your training data was limited to a certain bucket, in intelligent cognition, the machine is in a position to learn and adapt basis what is already been provided. And the last is where we call as intelligent decision making, which is automated decision making. Now, across the globe, various jurisdictions have been debating on whether ADM can qualify as JDM. It is very encouraging, and you rightly mentioned, sir, that the Supreme Court has initiated initiatives which helps in with research and translation, overcoming language barriers. Similarly, Estonia, as another country, has adopted AI #1 for speech transcription, which means that when a court proceeding is happening, the AI transcribes it, and then it anonymizes it in sensitive trials to prevent, to preserve actually privacy. A variety, a bunch of things exist. In fact, we don't have to look very far. If you look at China, there's something called as Project 206. Project 206 does a bunch of judicial support activities starting from case management to evidence collection, where it identifies what relevant facts are, irrelevant facts are, what evidence is correct, what evidence may not be appropriate. All of that is being done by Project 206. Going to US, and this is a little unpopular. Perhaps people may have heard about what was happening with Compass. Compass was an AI-enabled tool which predicted offenses and was significantly influenced by racial biases. And this was questioned in two court judgments. One was in Wisconsin, where the typical problem of, I will come to this problem, a black box problem was highlighted. And the court held that the black box problem is not a real problem when it comes to JDM. But at the same time, the Kansas court on the same software gave a completely different judgment saying that this is not in alignment with rule of law. So, first, the three concepts, intelligent perception, cognition, and decision making, followed by the very wide array of adoption of ADM into JDM processes. Now, Aparajita, as you rightly mentioned, what are the problem statements? Bias. Bias in heuristic standard is one of the most singularly significant problems. Why is that so? Bias is basically a translation of human bias. So if you see, go back to 2017 when India did not have a right to privacy, if we were to use JDM to decide whether Indians deserve a right to privacy, I don't think we will all be discussing about privacy anymore. Why so? Because all the past judgments before 2017 did not singularly recognize information privacy and privacy as a fundamental right. They were always attached with certain factual context. So if an ADM were to be sitting there and deciding and not our honorable justices, I think we would have landed at the same sort of an outcome where there would not have been a uniform resounding judgment saying that there's a right to privacy. Why? Because it would have been trained on data sets that would have exhibited the heuristics of judges as it exists. So that is number one. Judges suffer from a variety of biases when they adopt artificial intelligence tools. For example, commonly considered as hindsight bias, which is very prevalent in the US. So, in low-risk matters where there is a jury trial happening, if you're using an AI tool, it could suffer from hindsight bias as to how racial discrimination has worked, so on and so forth. You might end up saying that, okay, that neighborhood is largely populated by a certain kind of color, and therefore the rate of crime is significantly higher. So this is one of the illustrations of what we call as hindsight bias. There's also recency bias. So frequent times, a number of times if a particular incident has occurred, then the AI starts believing it as a fact. It will not go down to verify whether it is a fact or not. So these are significant biases that can impair how judicial decision making works. The second piece is black box problem. What is black box problem? Even technical experts grapple through this. Black box is the undefinability. You can't really explain how machine learning is working. And this is because of the various layers of neural networks within which the data is getting transmitted. So as a result of which there is a significant degree of opacity which translates into lack of transparency. So applying an AI tool for JDM might significantly suffer from black box, as happened in the case of Compass, where the petitioner actually stated that I need to know what is the algorithmic logic that has been used by this particular tool. And the court was unable to explain. Apart from that, there are various problems.
So we'll come back to your
Sure,
absolutely.
absolutely.
On this. Well, we'll have to pause a bit here for a very important mandate of group photograph because that's how we were supposed to begin it. So for 2 minutes quickly, if you can come forward, I would request all our distinguished panelists or a group photograph to come forward, and then we can continue with the discussion.
Fortunately, my wife's office is right next to, some good chambers. So, I will just probably next to but then waiting
Yes, so we can continue with the session now. We have started with the question of constitutional morality, constitutional values, and how do we align them with AI. We have also looked at some of the challenges, implementation challenges. Now I would like to move on to Sharpal sir. I have a very important question here that while we've been discussing about integrating AI into the judicial system, there's another important question here, which is that it's all about reducing the burdens on the court. And can AI help resolve disputes outside the traditional adjudication system remains to be a very, very important point to be deliberated upon. So on this, I would like to ask you, how can AI tools enhance efficiency, predictability, cost effectiveness when it comes to other dispute resolution mechanisms? And what are your insights from a practitioner's perspective? What challenges do law firms face with respect to dispute resolution structures by incorporating AI?
I think in terms of the speed of the decision making, the ability to collect data, to sift data, the issues in relation to bias questions, the issue in relation to the question of matters in a way which you have to resolve. All these matters are active matters. They have been addressed. The aspect in relation to what is not resolved is the black box. The other of decision-making processes, any AI tools, the question of whether the judgment is really delivered by the mechanical means or is there a human being at the end of the process, and it is the human being which has rendered the decision. If the decision is passed over to the machine, it would be bad law because no one has delegated that power to the machine. Even in selection of an arbitrator or selection of a mediator, the decision is such that the party has delegated. The decision is that has the delegation of authority been made to the person individually and has not been made to the machine. So this is a typical characteristic or differentiation between the process as it is. In fact, it could be a ground for setting aside an arbitral award under the New York Convention. Uh, the disclosure, the transparency, party content, the supervision of the AI generated, and the non-delegation of decision-making process are keys as far as the process of resolution is concerned. When you take the law firms of the there are multiple purposes effectively get resolved. The aspect of segregation of evidence, the aspect in relation to collection, the aspect of dealing with the evidence, the question of preparing a list of dates, the question of a due diligence which is conducted on the data available, are all matters which are procedural matters where the machines have resolved the question of speed. So there is a clear crunch to the time that is taken, but it does. You have to be careful that you do not get into the problem of bias or hallucination. There is a machine-related hallucination, which typically happens when you spread your data and you allow external inputs into the data, because the machine scrapes the data from the access to which it is amenable. So the question is that do you get wrong parties, do you get wrong judgments into the process of decision making? This is a common complaint in relation to processes where the machine has been let loose in the manner in which it is decided. So there are several judgments, even of our courts, where this question has arisen. Parties who are not parties to the original proceedings found themselves into the array of parties. The question of whether there were false judgments, in the sense that the name was familiar, but the contents of the decision were just not correct, and they had sort of manipulated the judgment. In fact, lawyers were found to be resorting to this particular technique, and therefore the human supervision over AI has to be ensured. It's not a hands-free kind of situation. In two cases, in the Gamma versus Chennai Metro Rail Corporation, the Chennai High Court actually developed a procedure whereby engineers worked with the court and they prepared four principles. The system must be confined to the record, so no access to external stuff. It must not invent, infer, or give legal opinions. Only present, only re-expressed, retrieved experts. Outputs must be traceable and viewable under against the record, and all interactions with the procedural or substantive must be logged and must be available for transparency. The question of transparency was also discussed in the sense that if you put in more data, if parties are accessing stuff which is not in the case, and external material is resorted to, you have to advise the other side. And these are matters which are decided when you really set down the principles which will be applied in the case or in the mediation before you actually prepare your material. So the agreement between parties and the expanse that you really are going to cover is a matter of agreement, especially when you are resorted to AI. So in the case of Deepak versus Heart and Soul Entertainment Limited, the question of fake generated cases came up, and the court came down very heavily. In US, for example, there are sanctions against a lawyer where he does not supervise adequately, and the case is left to be open-ended, and the resource question has to be looked at. In the problem of KMG Wires Private Limited versus National Placement Assessment Center, the government was accused of fixing the process in a manner where it results in a particular outcome, and that was punished for the reason that the outcomes were prefixed, and therefore there was no freedom in decision making. And the process effectively therefore proceeds on that purpose.
Thank you so much, sir, for your insights. And all of us in the room here would agree that we need to shed our hesitation in AI when it comes to adopting this technology. But while saying so, it's also important that there has to be a responsible adoption of AI, right? It means calibrated deployment. And coming to that, we need to learn more about how to exactly implement and deploy AI. So we need to learn about use cases. And I think Rajneesh would be the best person to inform us and give his inputs on the use cases in judiciary when it comes to adopting AI in a responsible manner. Over to you.
Thank you, ma'am. And while I was listening to the insights, as Maheshwari sir said, this is not human versus machine, and Professor Vajpayee said, it's not automated, but augmented. And I'm from the National Governance Division, we do a lot of IT projects for the government. We deal with a lot of challenges in our own work also. And I will touch upon one aspect of judiciary. The judges are not confident that whenever they use tool, is it going to USA, is it going to Russia, is it going to China, where are the servers located? So we found a very interesting solution. That for all judicial cases, say last 50 years, we want to put it in a server. There will be a device called a NAS, network attached storage. You put it in the judge chamber. You have it connected with say a MacBook Pro or a Mac Mini or just Intel server. And then you have a data diode, which means that it will only let you access data, let nothing else come to the data. So one of the great challenges that any judge would face is, what about my drafts? So there has to be a complete data erasure mechanism. When the judge removes the machine from its place, the machine should have absolutely no trace of what was done by the judge. All this is possible, and it's a sub-10 lakh solution. The only challenge that here comes is, as Madam had said, how do we build a good tool which can assist the judge? So it's not human versus machine, but one thing that will come is that there are mechanisms for guardrails. That is, the problem with LLM is it never stops. It will never tell you, I don't know. It will keep answering. So that is the thing that lawyers, technologists, LLM experts have to come back and sit and say, you stop here and say, this is all I know. Last 50 years judgments I have checked. This is the reference, and the legal assistant of the judge or the adjudicator can always ask the assistant, what is the reference? Have you cross-checked it? And the cross-checking also can be done by the AI. So in a sense, if you look at the technology of LLMs, it is a adversarial network, wherein one part of the network is doing something, other part is outdoing it. So it's a self-criticism mechanism, wherein you get the last solution as somewhat correct. So one thing more that relies with the legal aspect of using AI is hallucination, which is so accurate that even the greatest experts will fall prey. As just Sir gave an example that some case was concocted by some other references to the other places. Now for that, we can have another AI system in the mechanism itself which keeps that counter. So all I can say, ma'am, is, and sirs, that if the technologists and the legal experts come together and we build a sovereign LLM, which a lot of companies in the country are doing, it can be a real assistance to the close to 650 district courts, 25 high courts, and even we tackle a lot of adjudicators, not just the judges, the NCLAT, the NCLTs, income tax separate tribunals. In those cases, it is not so difficult also, because most of the arguments or cases are, very fact-based, unlike a civil or a corporate case. So, my suggestion to the panel is, let's start with the adjudicators, the tribunals. We have a learning, and then that can very easily come to civil and corporate cases. On criminal cases, I'm not very sure because we have to study that aspect. But as far as civil and corporate cases are concerned, in the real case of a simple machine being the adjudicator, connected to a network attached storage, and that network storage is a very interesting thing. Anyone in the world can access it because network as was safe, and no one else can access it. In fact, we can also prove all connections withdrawn. No Wi-Fi, no Bluetooth, no LAN connection, and still the machine is work and video for judgment or a draft. That's all I can say. Thank you.
Thank you. That was some real finding here. To all the audience here, I think you would agree with me. We've got some very, very important key takeaways from the three important conversations which we've already Had. Moving on to Vikas, you have been very active in judicial automation tools and also towards dispute resolution. The question still is AI-driven automation. How would that improve judicial efficiency, case automation? So can we have quick input from you as well?
Thank you very much. Let me start with what we are already doing. Let me tell you what is it that we are piloting right now and therefore likely to be in place in a couple of months and what is the future going to look like. We are already, as some people might know, we are using transcription to transcribe Supreme Court proceedings and constitutional bench hearings. We're doing that not just in India, but in Dubai International Financial Court, the Abu Dhabi Court, the Post Supreme Court. So I wanted to give that background to say what we are building in India is not just for the Indian courts. Obviously, the Indian courts is one of the biggest consumers that we want to address. The need is much there. But I think it's also about taking that step forward to say what is it that we can build where we're not copying or adopting what other countries have done, but really setting the standards to do what is possible. For instance, in the ADGM courts, one of the things that we're doing is live translation of court hearings, where in special economic zones, where the language of proceedings is English, but the parties are not English speaking, parties often struggle to follow what's being said in court. What we have offered is a solution to convert that into Arabic in real time with a significantly greater accuracy than even a human translator doing it in simultaneous interpretation. Those are the kind of things that I think we need to start looking at and importing into India. But I think we've done more than that. Today I can tell you that there are 3 live pilots that we're doing where a lot of what the theoretical discussions we're doing has already been put into action. We are looking at building systems that are tuned specifically for judges to use AI responsibly. AI that does not tell them what the decision is, but gives them everything else that they need to do to make that decision much faster. It's everything that lawyers have already been using. Sir already talked about, for instance, the list of things, the factual chronology, but we go beyond. We look at how we can analyze cases in a manner that will surface the positions of the parties, the points of agreement between the parties, the points of disagreement between the parties, the key legal principles, and where the key legal principles are there. We are working directly with the judges to identify the key 50, 100, 200 cases per roster. Because obviously you might have 17 million cases in India, but all of us know as lawyers that you don't need all of them to decide every case. There are some key principles in each roster. We're working with the judges to identify them and surface them literally as the pleadings come in. Where we see it, the judges look at cases in 3 the day before the hearing, when the list comes out, where you have about 30 matters that you need to understand. So you have about 30 seconds to a minute to read each case. 5 seconds between when the lawyer is walking from his seat to the podium to argue a case. You have 5 seconds to literally try and understand what the case is. And then you probably have about half an hour or an hour to decide the case and draft the judgment. So we're building tools which have all the guardrails that are here to address each of those 3 elements and tell the judge what they need at each of those points. At none of those points are we telling them what to decide. All we're doing is distilling the position of the party. And our aim is, as we go forward, that distillized position is actually given back to the parties. So when you're talking about transparency, when you're talking about no hallucinations, when you're not talking about AI's limitations, what better way is there than to put it back to the lawyers to say, hey, listen, this is what the AI has said. I will of course apply my mind, but if you feel that there are gaps, if you feel that there are issues that this hasn't picked up or that characterized it wrongly, it's your chance to then give your input on it. So imagine a hearing that is happening after all of this synthesis. So instead of the lawyers starting with saying, this is the fact, this is when X was born, Y was... You start with saying, the judges already know what the agreed positions of fact are, so let me get straight to the disputed positions and economize on the time required for hearing. Add to that the transcription that you're already doing. So you're not just synthesizing digital data that is your electronic filing, you're not just synthesizing the evidence that is already on record, that with our RAG systems, which are fine-tuned to the judicial models, are retrieving only the most relevant ones in a more limited data set. But adding to that a hearing where all these positions get crystallized, and therefore when the judge sits down for that half an hour or 45 minutes, they really have not a static document. They don't look at a petition and then say, okay, this is what the position was 10 years ago when Martin was arguing. But literally how the position has evolved from that day over maybe, hopefully not 10 years, but until the time that judgment is delivered, what is the evolution of the party, where is the points of agreement, so that immediately you are able to distill out and generate a decision, which is your decision, which is a human decision, but augmented with technology. So I think a lot of these are not being done in the rest of the world. You're looking at automated decision making. You're jumping the gun. You're going from saying, I'm going to give you all the data, you generate an output and give it to me. We're saying, don't do that. Let's keep the human in the room, but ensure that you use all of the benefits of technology to aid the decision maker. And that's literally what we're doing today with arbitrators, with judges, and with arbitral institutions, all of whom are looking at making some very critical decisions on very high volume data without the use of technology, because today technology is, it's inaccessible for all the reasons they said, sovereignty reasons, black box reasons. There are also elements about where is the data getting stored, where is the data getting processed. So when you build systems with the judge, with the arbitrator, the institution at the very heart of the solution, you will automatically program for it. And when you have these guardrails embedded, it also makes it easier for parties to accept. So when we build rules for arbitrators, and the arbitrators tell them, listen, I'm going to use Microsoft 365. They're like, okay, will the arbitrator ask Microsoft 365 to tell them what to decide? Because Microsoft 365 will give you an answer. But on the other hand, if they use a tool that we've created for them, which will tell you that I cannot give you that answer, it is beyond the scope of what is the permissible use of my platform, parties are more likely to consent to the use of that kind of technology. So it is really that which we start off with, saying, look at the key decision maker, because they're the ones who are scarcest, who are the ones who need to do the most. How can we help augment their capabilities? And also think about this in the context of judicial thinking. We are working with the brightest judges across the country in the Supreme Court to distill out how they think the case needs to be analyzed. And we are building systems with that knowledge and logic. And that is being used by the district court judges in the hinterlands of India. So they now suddenly are applying frameworks that have been designed by the best of experts in the country to do their work for them in the language of that judge. That I think is the true power, and that's what we're looking at, when we're looking at the directive concept, we need to look beyond that to say, how can India contribute not just to taking what's happening elsewhere, but really
Vikas, I have to interrupt you. I'm so sorry. Thank you so much. That was quite insightful, and you actually made us imagine the entire courtroom exercise, which will be a AI-enabled courtroom. So thank you so much for that vision. Now, as we are moving towards concluding the session, I would like to again come back to Shardul sir. So what are your insights on the deployment of AI? Should it be restricted to decision support or assisting the decision making, or the real decision making which is done with the help of AI? And where should that line be drawn? So if we can have insights from you.
As I mentioned in my opening statement, one of the question of bias and the question of fair decision is this precise question as to whether the judge-made decision has to be really automated, or is that something which can be only restricted to the human being behind the
It's going to, so we can go in some other room. We can go in any room.
In USA, they have actually, and several of the tribunals which have really made their tools, one of the principles that they have embodied in the decision is that they have delegated that authority to the natural person and not to a machine. So you can find that the line has been crossed, and it is not just the procedural element, but the judicial element, which has been decided to be a bad decision, because it is not in accordance with the entrustment of the matter, which was based on who is the judge and how the processes are effectively evolved. So that's the solution which has been found, and that's what is likely to happen in relation to future matters.
Thank you so much. And now I will request Justice Maheshwari ji, if you can give your concluding remarks. We'll start from the same question here on for concluding remarks also. How to integrate AI into the judicial system while ensuring constitutional values at the same time?
Yeah, thank you so very much. It was a wonderful insight from our analysts over here, and things we keep on learning. As we learned today also, that we have the capacity as human beings to learn and also to apply. The capacity we have to develop about the AI or any machine, the tool also We have to inject that capability to unlearn or at least to block what should not be learned by that or what should not be used by that. Because as you rightly indicated, that if, well, there is a propensity to generate fake, not only deep fake in the sense of images, but even citations and decisions. Well, there would be, well, that AI would be countered by another AI, well, blocking, well, anything of fake creation. So the possibilities are abound. Possibilities are plenty. We keep on proceeding. But one of the common features, factors which we were discussing have been about the actual decision-making process. Because all said and done, at the end of the day, it's so if we talk of the court, the justice delivery system. Well, it is ultimately delivering of the justice. As judges, as we know, we are saying all saying about. There is always a difference between disposal of a matter and delivering of a justice in a cause. And the effort of lawyers, the whole system is delivering justice in a cause. So far as this background or tendency, etc., well, they are of concern and regularly efforts are being made. Their machines, to the extent they help us, in sifting through volume of data, etc., and well, generalizing the things proper. They are of immense help, and we are indeed using them, and we are going to use them more. But then, helping the machine to articulate a conclusion, or using a machine help us in, or rather leading us to a conclusion. So there has to be a difference. There is a difference that is always made. The other day we have been discussing the idea about sentencing policy in criminal justice delivery system. Discussing we are working on that. When all said and done, we know that in that criminal justice delivery system, in the end of the day, after conviction, the learned judge would be looking at all those aggravating and mitigating factors for deciding on the appropriate sentence. And there, that particular decision making will be a human decision making only because that has to take into account a variety of factors, ponderables, incontrollables, and surrounding factors. Friends, I have an interest to share with you that in our Indian philosophy, the aesthetics, we have those concepts called lovers. These are those 9 human emotions or sentiments, starting from love, then the first one, then laughter, sorrow, anger, energy, fear, disgust, wonder, and finally peace. Now these are human sentiments, and they are integral part of decision making when we are dealing with human beings. And these are the factors where a human brain who is capable of empathy is at work. So we take the help from machine for sifting across the things, putting the things in order, but then at the end of the day, the final decision making definitely remains with the adjudicators, and there we ensure, we all as the law professionals, what is required for us to ensure is that since we all are dedicated to the constitutional morality, this black box system, whatever we use, it remains a glass box for all of us, transparent altogether. Thank you so very much.
Thank you. Thank you so much, sir. And as we conclude with this session today, there are 3 important reflections which stand out very, very clearly. The first reflection is that technology is no longer at the periphery of judicial system. It's already becoming a part of the main architecture of this entire judicial ecosystem. And all kinds of initiatives which Supreme Court has already taken, they very well demonstrate that we are on the way towards institutional reforms for adopting and adapting to this technology. The second important reflection here is that no matter what, every development, every technological advancement, every framework which we create should be constitutionally anchored and human-centric in its approach, because it's we human beings who are at the end of it. And the third very important reflection which emerges today is that the future lies not in replacing human beings, which is the extension of the previous one, not in replacing the judicial system, but in strengthening the entire system when it comes to equipping courts and judges with tools, technologies that enhance research, streamline case management, and reduce pendency, and of course, expand access to justice. So with this, the roadmap ahead, which is a very important key takeaway from this important panel discussion. The roadmap ahead requires clear ethical guardrails, it requires transparent implementation, it requires institutional oversight, capacity building within the judiciary, and finally, and very important one, continuous public trust. So with that, we conclude the session. Thank you very much, everyone. On behalf of National Law University, Delhi, I extend my sincere gratitude to all the panelists here, Justice Maheshwari ji, Shardul sir, Vikas, Arya, Rajneesh ji, to each one of you for taking out time to join us for this panel discussion. I also extend my sincere gratitude to my team, to India AI Impact team, Dr. Sonu Gupta and her team, for giving us this important platform for this deliberation today. And to, of course, all of you, each one of you, all the participants, for your thoughtful attention and engagement today. So, with this, I would request my colleague, Dr. Dakshina Chandra, to present a token of gratitude to the panelists here. This is the memento from MIT as well as National Law University, Delhi. Shardul sir.
आप उनसे आप एक मिनट लगेगा ना? हाँ, देखते हैं, दिखाऊंगा। उनसे बोलो।
Thank you very much, everyone. Thank you.
आप इसको लगा के देख लो जब तक, इसको लगा के देखो फिर। इन्होंने नई तार भी मंगा ली वैसे तो, नई तार भी मंगा रखी है। ये लगेगा नहीं ना, स्लॉट भी तो इसका ऐसा है, ये भी नहीं लगेगा।